Christine's presentation explained to us how the definition of surety bonds has been changed, which really could affect people's ability to get bonds. The definition of soil borings and whether they're accurate and complete has been changed, undermining the warranty of accuracy upon which we've all relied for many years. If you fail to make a notice of a claim on time, it's irretrievably waived, at least according to MnDOT, and they say it repeatedly so you know they mean it. You know, they've redefined tolerance into something that doesn't mean tolerance anymore. They've separated entitlement from quantum, but you can't improve entitlement unless you refer to quantum sometimes, like a schedule, which they define as quantum. It's great. The question was, have you ever heard MnDOT claim that their decision should be given deference and that the judge should just declare that it's not a changed condition because MnDOT says it's not? Yeah, we hear that a lot, that they should be given deference. But remember, you know, if a soil boring is accurate, it's accurate or not. And if MnDOT thinks it's close to accurate, it's no more persuasive than your experts saying it's not. So you typically get around summary judgment with that type of argument, and then you get to the jury. Now, what I'm going to talk about in the tail end here is Section 17, 18, and 1900. And let's talk about only the major risk changes, like the Data Practices Act. They now say that you've got to provide data to the public to the same extent MnDOT does. That's a radical change to the Data Practices Act. Today you don't have to do that. When this goes into effect, you will. Now that won't apply if the data is in MnDOT's possession, but frankly most of the data on projects is yours. So if MnDOT doesn't have it, you've got to reply to the public. Hopefully there's a current case in front of the Supreme Court, the Johnson Controls decision, which will put a stop to this, but we'll just have to wait to see. You've got to remove an employee. Remove an employee if their behavior doesn't comply with MnDOT's harassment guidelines until there's a complete investigation. I'm not sure that complies with due process. It may not comply certainly with your union grievance program, but that's a change in the law and the compliance with the Human Rights Act statute. There's a false claims section. MnDOT redefines false claims. Remember I said it relates to a pay application or any application for payment. Well, they want you to say now that we're going to certify that every statement and document that we submit to you is accurate. Well, you hope it would be, but even if it's not, that's not a false claim. So I think what you need to do is, on anything that you submit, is state that it's now to the best of your knowledge or reasonable knowledge, just so you can get around that type of allegation. You know, do you have to restore surfaces opened by permit? Well, we got some relief here that if the permit and the utility work is not in the package, then you might have a compensation claim. If it is, and they let you know that there might be collateral utility work in conjunction with your project, well, it's supposed to be your risk. So the interference from third parties is still a risk that is open. Yes. Railroad highway provisions, they deleted a number of things that used to be more cooperative. They deleted the language that MnDOT would secure all necessary easements over a pre-existing private crossing. And that's now your risk. A practice point here, I think, is to request clarification before submitting a proposal which easements are your responsibility to pick up and which MnDOT has already obtained. More railroad issues. You got to submit your safety plan on time and by a certain date. Unfortunately, MnDOT doesn't promise by which it will get their plan back to you. So it's just, you've got to factor that into your schedules. Temporary bypasses, they've deleted language requiring MnDOT to design and install and maintain these necessary traffic control devices over necessary bypasses provided in the contract. It's just another example of more costs MnDOT are trying to transfer you as what they would call an incidental cost of the contract. Now, they've deleted the provision in which they're going to compensate you for furnishing and maintaining and controlling traffic control devices. MnDOT says, well, that language is now redundant because it's covered in sections 1402 and 1902. But those sections really cover claims for additional work in contract revisions. So again, another example of an effort to make these types of costs incidental to your contract. Let's turn to their expressions of general liability that they wish to impose on a contractor. And this is their claim for indemnity. They say we want the contractor to hold us harmless from damage to property for any act, omission, neglect, or misconduct. Well, I think neglect and misconduct is fine, but any act? That arguably imposes strict liability, whether it's negligent or not. There's a recent Supreme Court case, the Bulldog case, when evaluating insurance provisions, which said, well, we've got to imply the word negligent in front of act, otherwise we're going to create strict liability and we don't want to do that. But there's no such decision on this specification, so it's a very broad imposition of liability. It could be equivalent to an indemnity without fault, which, by the way, is illegal. Under this provision, they want you to defend and indemnify them from claims relating to bodily injury or property damage on account of the operations of contractor. Again, no reference to fault. If it's not based on fault, according to MnSTAT 337.02, the anti-indemnification statute, that's illegal. So it's important to keep in mind. Christine mentioned this again, but it's repeated here. If no money happens to be due a contractor on a job, MnDOT can hold the sureties liable if there's a claim for indemnity under this provision that is still outstanding and has not been settled. So if they want to hold you strictly liable for without fault, but the project is nearly complete, they intend to think that your surety will be liable for that claim. I can tell you sureties are not comfortable guaranteeing indemnities like that are not based on fault. Again, this will threaten bondability. They want you to waive subrogation on your workers' compensation in favor of MnDOT. And, I was talking to Roger Cornett about this before the seminar, and I think that's possible. It's going to cost a lot of money, though, and it's going to be detrimental to subcontractors because this provision will flow down to them, and this could upset a way a lot of workers' comp insurers look at these projects. And as for their workers' compensation insurance, here's what they specified. A contractor shall maintain insurance to cover liability from operations. Well, I sure wish that were true and possible, but you can't get insurance that broad. Again, it has to be based on fault. Just cannot liability that may be imposed on you from operations, just too broad. Again, under the anti-indemnification statute, if you can't get insurance in the marketplace, if it's not commercially available, then you should tell MnDOT that, and you'll be relieved from the liability. Unfortunately, if you tell MnDOT that before the bid, you'll find your bid is conditioned, and they'll reject your bid. So this is really something that MnDOT should change, because they can't impose a liability like that immediately puts you into breach as soon as you sign the contract. And note that they're able to terminate you if you fail to get the insurance that they've specified. So this is a problem that needs to be resolved. In regard to air, land, and water pollution, you're supposed to suspend if you encounter an indicator of contaminated soil, which is all good. But their definition is a bit rich. It's an odor, a can, wood, glass. This is not necessarily an indicator of a contaminated condition, but we asked that they infuse this definition with a reasonable belief, but they thought that was redundant and that this is fine. So again, err on the side of caution. You encounter a piece of glass, let them know. So, stormwater management. Well, I'll let you read this slide. We tried to get them to take responsibility, at least for floods. They said no, that would violate NPDES permits. No, it wouldn't. It's allocation of risk according to the same permit. We threw the pitch, but it was rejected.